court agrees with the petitioner, then the said Dancer will be condemned. I therefore sustain the objection and make an order that paragraphs 80 and 87 of the affidavit in support of the petition be expunged for wrong character. You may proceed from there.
Most obliged, my lord. It is the petition, not the affidavit. It is 80 and 87 of the petition.
Of the petition?
Yes, and paragraph 37 of the supporting affidavit.
Okay, let's proceed. We start when I think you know where we stop.
Yes,
So that
my lord.
we proceed.
Then I was inquiring of the petitioner on whether he wished to have the court take a look at the video evidence that are annexed to his petition. My lord, the risk with the striking out, I hope that it's only because there is our next chapter, the video clips, relates to other incidents, but it was an affidavit at paragraph 37, so that to the extent that I'll be seeking possibly, my lord, that you review your order, that paragraph 37 be amended accordingly as to expunge the name of one Dunstan Omari from it, but the other contents, especially the reference for a review of the court's order, is because Annexure ORM 6 contains 3 videos, of which only one relates to the Dunstan Omari incident at Hon.STEPHEN Primary School. So that striking the entire paragraph out will, in a sense, lock out crucial evidence that the petitioner intends to rely on in the petition. I'll just add that the respondents stand to suffer no prejudice at all, considering that your order that you just meant, the ruling, was specific, that the offending parts of the petition and the affidavit relate to Dunstan Omari only, so that we can be then allowed to have the court look at the other video clips.
Yes, my lord, we are opposed to the application to review the court's decision on 2 grounds. One, my lord, that the court has not reserved its reason. It has given a reasoned ruling after considering the objection made by the third respondent, and I believe, and we all believe, that the court looked at the totality of the paragraphs that it has made a decision to expurge from the record. If my learned friend or his client feels aggrieved or uncomfortable with the decision, then he can await the final determination of this petition so as to make that part of his grounds for an appeal. My lord,
Yes.
the second reason, my lord, is that the court has not made any determination in relation to video evidence. And nothing curtails my learned friend and the witness from introducing whatever video evidence they want to introduce, subject to the respondents indicating to the court whether they object to a particular video and for what reasons. I believe we need to move on with the remainder of the witnesses' testimony.
My Lord, I associate fully with the submissions done by my senior and others follows. My Lord, this court is a court of record, a court of law, and we play by the rules as legislated. My Lord, an application made soon after a ruling has been made for review is, to say the least, an absurdity on the procedural laws as we know them to exist. My Lord, the court was informed of the submissions ably made for that ruling to issue. There is no new material that has been presented before you warranting the Honorable Court to review its orders. There is no evidence that has been presented before you in terms of videos that may, at the end of the day, present a situation where an attempt to review the said orders can stand. My Lord, we are here. We are eager to proceed with the hearing. We do not wish to make this back and forth applications, introductory applications, so that there is progress made, but that progress must be aligned to the law. Not even Article 159 2D of the Constitution can cure this kind of application that has been presented now. So, my Lord, kindly disallow that application for review, because it is a slap on the rules as we know them, and let's proceed with the hearing.
My Lord, if I had my senior here, he wasn't opposed to us producing the video evidence. It's on record.
I think the best thing, let's just address our mind to the issue so that we don't mix this issue.
If I had my senior, my Lord, Eric Moturi, he said that we have not yet presented the video evidence for them to oppose or not to oppose. My application, my Lord, and he's here, he can confirm. He was saying that we have not.
I have had him.
Yes.
This is your chance to have a rejoinder so that we do not almost quoted somebody the way one of you was quoting somebody. Okay, sorry.
My Lord, I was saying in response that if I had my senior Eric Moturi right, he said that he does not.
Are you saying you didn't hear him? I thought it's just a rejoinder so that we move faster.
So that the reason why I'm saying so, my Lord,
Yes.
in rejoinder, possibly each person has his own way of expressing themselves, but what I was saying is if I had him right, he does not have opposition to you seeing those videos, if I had him right. That my application for review was premature.
My Lord, if we proceed like this, much as it is basically an issue of reply, a response to the
I'm
issues
replying.
that you have raised.
I have my own way of replying. Whether they
Mr. Auto, please, just reply the way it's required.
Thank you, thank you.
And that's why I was.
My Lord,
I've interjected once.
thank you. My Lord, awaiting considering the strict timelines with which election petitions have to be heard and determined, the proposal by Senior Counsel Eric Moturi that we wait for the final determination of this petition and then appeal will mean, my Lord, that you will never have an opportunity to look at that evidence, and that will deny a party, my Lord, a right to be heard, considering we have a very short period to work with. My Lord, the review that I was seeking was because the annexure that the court had just, and my colleague here was submitting, that the application for review has just been made a short while after your ruling. What we were seeking was that we are not trying to tell the court that there was new evidence. We had just lumped the videos into one paragraph and marked them as ORM6, so that the order of the court expunging the entire paragraph, not only the offending part referring to Dunstan Omari, is what, my Lord, we are seeking that you kindly review. My colleagues will still have an opportunity to challenge the evidence through cross-examination or even oppose its production if it will be offending or against the court's law. So that we are not seeking that you review your entire ruling, because we respect the court's decision and discretion. We're only seeking that that part that also excludes other evidence not relating to Dunstan Omari be allowed, because the context of that ruling, my Lord, means that we may not be able to refer to that annexure and have you look at that evidence. That's what we're seeking. I think it's not new evidence, but I think it's because of reference to the annexure to that paragraph and other evidence.
And I seek, when you are doing an agenda, don't keep on repeating, so that you know you may have a very important point, but when you are repeating, I may assume it's something like that. So it's good to be precise, so that I capture you and don't omit anything.
I believe, my Lord, I've given my all in response, and I'll be guided.
My Lord, I know I don't have any right of
You don't.
I don't.
You
But
don't.
just to have the court, to invite the court to paragraph 12 of the supporting affidavit, which is another clip, paragraph 40, which is also another clip, and paragraph 37.
Asante. So that I'm not accused of listening to one side. Mr. Nyamira.
It was not record, my Lord.
Okay. is what I'm saying. My ruling on paragraph 80 and of the petition and paragraph 37 of the supporting affidavit was very clear. Reference was made to the mention of Dunstan Omari. My ruling did not block any other evidence from being adduced. The review sought is therefore declined.
Most of them. My Lord, will request them to kindly play the
Videos that we wish to have the court take a look at.
I thought is the witness who lays the foundation
Yes.
on with the evidence. And when he says he would wish to, then that is when, if they have an objection, they can raise the objection.
My Lord, what we'd assumed is that upon the adoption of, because we wanted him cross-examined, we just wanted, unless we had to start reviewing the evidence, my Lord, so that for
Are
us,
we in communication? Gentlemen and ladies, are we in communication? I don't know whether I'm communicating.
On my part, you're communicating because what you're saying is that the witness needs to say, this is what happened and this is what I did.
that's fine.
A brief foundation, a brief basis on which now he can say, I wish now that the video clip to be played. So that if they're objecting, and somebody reads my record later, it does not say you objected when there was no application. Are we together, Mr. Joki?
I'm well guided, my Lord.
Oh,
Now, confirm that in the petition that you have filed, the results that were announced by the second respondent are different from the ones that are in Form 35B.
I can confirm that.
What?
Just a moment. Just a moment. Yes.
Are you able to tell the court what results were announced?
Yes, I'm able to tell the court.
Please do.
For all the results.
No, those ones that were announced.
The third respondent was declared the winner by 16,877
Just a
votes.
moment. Yes, you said 16,000.
877 votes.
Yes, proceed. What was filled in Form 35B?
The 35B, they fill the number 17,097.
What?
Just a moment. 17,000.
And 97.
17,097
Yes.
votes.
A total of 220 more votes.
And for the record, just confirm the margin of victory, the margins between yourself and the third respondent. Are you able to tell the court? Or you will need to do the maths?
We need to do the math.
Okay, you can tell the court what you garnered, what was declared for you.
I was declared
Yes.
with 16,524 votes.
So
Just a moment. 16,000.
524 votes.
524 votes.
so that the initial declaration had a margin of how many votes?
353 votes.
Did you manage?
Just a minute. Yes.
Do you have a recording of that declaration of results as done by the second respondent?
Yes, I do. Marked as evidence, ORM.
Just give me a chance to write. I'll prompt you to proceed. Yes.
Marks as evidence, ORM 6.
What is it?
It's a video.
Could you wish to have the court take a look at that video of that announcement by the second respondent?
Yes, Your Honor.
Confirm that you have a flash disk with that video and you wish to have the same plate.
I confirm that I have the flash disk here with me, and I wish it to be played before this court.
Objection?
My Lord, on our part, we have responded to that issue in our supporting affidavit to the response to petition. And on account of that response, we will not be objecting to that pronouncement because we will be submitting on the law on declaration of results.
Okay. So you have no objection?
Yes, my Lord.
Mr. Gade?
My Lord, for the benefit of the court, let the video run. If it has run, then we can make respective submissions because we have responded to it substantively.
Okay. The video run.
Is it one video or the?
Clip.
Is that
one.
It's a clip.
Yes.
It's a video.
Yes. It doesn't involve the other issue.
How long is it going to take so that we don't take the whole day here?
No, very
Mr. Gade?
briefly, very short, just the relevant parts, the announcement only.
And you should be giving us time, I mean, very short or very long, they differ from one person to the other.
Less than it's a minute and a half.
That's okay. That's all we want to know. Do we, ICT?
Yes.
Do we have our speakers working well?
Not that one, not that one.
You see now that is the problem, no? You need to be specific, no?
No, not that one.
I don't think you have that.
That's
so that it beats the correct one. Pause fast. Pause fast. Before you. Just add the volume. I think the volume is a bit low for me. My ears are a bit from Mr. Moturi.
It's maximum of it.
Is maximum?
Yes.
Okay. I'll try and key. Okay. Play on.
I'm now going to announce the results of the election of member of National Assembly that were held on 9th of August 2022 in West Subiano constituency. For those who don't know me, my name is Sylvia, the Chuba Poet, and I'm the returning officer for this constituency. Atopi John Kennedy, 651, Agata James Ogoti, 573, Arasa Oidere David, 170, Magamala Fred Okinyi, 2,561, Mbaya Onyota Vincent, 439, Misilo Walter Amani, MOGAKA Vincent Kemosi, 15,205. Moturi Dennis Anyoka, 1,023. Moturi Rodgers, 16,524. Nyamira Eric Achuki,
That's all, my lord. Possibly.
I don't know whether I got the figures correctly.
We can just go back.
Just a moment. Let me just clarify whether I got them correctly. Because all of you, and some of you have younger years. I got the first one at 16,877. The second one, 16,554.
Yes.
So those are the correct figures.
Yes.
Okay.
16.
Sorry? 554.
524.
Okay, repeat. Kwa sababu
Just
nilisikia kwa sababu
replace the figures.
kidogo tu, sio yote, not the entire.
No, just go back once. Ameenda sana.
MOGAKA M 16,877. MOGAKA Vincent Kemosi. Thank you. Let me know, please. MOGAKA Vincent Kemosi, 15,205. Moturi Dennis Anyoka, 1,023. Moturi Rodgers, 16,524. Nyamira Eric Achuki, 289.
Is it 524?
524.
Yes. Now I've had it here.
My lord, possibly we can just finish. It's not very long, including where he was issued with a certificate.
Is it necessary?
It's not
I don't
the
they issue the
figures.
figures, isn't it?
Yeah.
Okay.
The video clip is played. And nani amepata 1687? 16877?
The third respondent.
Sorry?
The third respondent.
The third respondent.
My lord,
Ngoja kidogo. I just want to just capture and because I have the figures. It's a question of just attaching the name to the figures. And the petitioner 16524.
Yes.
16,524. Yes.
Yes, we may proceed now.
My lord, I'll just request that we forward it briefly. You see the last part of it.
What is there?
Issuance of the certificate.
It's not contested that it was issued.
Is the issue of
The reason why we want the court, my lord, to take a look at that is there is subsequent evidence that there was alteration before issuance of certificate, so that you can just take a look that it was the events followed each
Okay,
other.
so
Yes.
how far forward?
It's almost done.
It's okay. Let's proceed. Just
Let it play.
Onyeki Evans, 236. Ongocho Charles Mongale, 766. Ongeo Douglas Orutwa, 295. But we have 15 candidates in the list. In the result, with the list of member of Assembly, 160. Ochayo Peterson Moguso, 48. Oindo Douglas Mokaya, 375.
just forward.
Vincent Omsitani Officer, hereby declares MOGAKA
Oh,
Stephen.
it's okay.
That's enough.
Nataka hiyo certificate. Nataka hiyo certificate.
the election held on the 9th day of August 2022. Constituency returning officer, myself, Civil Chamber, with my signature and my stamp. I'm going to call all of you so that when you come to present, and then,
My Lord, we are good. We are good with that one.
Okay, let's proceed. Okay, can we, let's come back to court. Najua hiyo celebration imetupeleka kwa mwingine, lakini we did not participate in Ogo Kidogo, hata waendelee. Yes?
Confirm also that in paragraph 40 of your supporting affidavit, you aver that there was impropriety on the part of the third respondent. Explain to court what exactly you are referring to. At paragraph 40 of your supporting affidavit, explain to court what you mean.
The third respondent is captured on a video clip where he's campaigning and is promising to pay the voters more money than the rest of the candidates.
John, I was trying to interject.
Yes.
Because we have gone to the second clip. We have not finished with this one.
You have not?
I'm saying,
Yes.
I believe the witness is now going to the second clip, which is on voter bribery, I believe. And have we concluded on the question of this particular one? Because there are three.
I don't know. Mr. Ochoki should tell us.
I'd wanted, my lord, I have 3 clips and I'll be guided by whatever directions you give. I'd wanted him to refer to that one so that when we make our application to have them produced, we do it both jointly, possibly as 6A and B, so that we move together. Yes.
Let's exhaust all evidence he has in respect of this case.
The first one.
Yes, the one that we have
That's
just
fine.
seen.
That's fine.
So that they are not mixed. It's also easier for the court to follow the evidence. If we follow one clip to the end, then he jumps into the other one to the end. Yes?
Could you wish to have that clip produced in court as evidence?
Yes, Your Honor.
And basically your contention is that the results announced are different.
No, we have objections.
Sorry?
We have objections to the production.
I was winding up before my colleagues object. I was just saying that your contention in the clip is that the results announced are different from the ones in the form that used to declare.
Yes, Your Honor.
That was given to you.
Yes.
My colleagues can object then.
My Lord, as I've stated, when the clip was about to be played, on our part, in particular, this particular clip, we don't object because we have explained it out. Yes.
Mr. Nyamira?
Yes, my lord, Mr. Mokwa is going to make the objections.
Sorry?
Mr. Mokwa, my colleague, is I've delegated that he's the one who's going to.
Oh, okay. Mr. Mokwa?
On behalf of the third respondent,
And it's Mokua, not
Mokwa.
M-O-K-U-A. And on behalf of the third respondent, we do object to this particular video being admitted into evidence for the following reasons. First, my lord, there is no certificate of electronic record as required by the mandatory provisions of Section 106, capital B of the Evidence Act that has been provided by Section 106, capital B of the Evidence Act that has been produced to accompany this particular video. Secondly, my lord, electronic evidence is documentary evidence, and as such, it is only the maker of the video who can adduce the video. But the petitioner is not the maker of this particular video. Thirdly, my lord, a very keen look at this particular video. It is edited. It contains parts which have been cut and pasted together to fit the petitioner's case. For this reason, my lord, we pray that this particular video not to be admitted into evidence. We humbly submit, my lord.
My lord, there is only me against 10 or so colleagues. I just request. I request.
It's not a question of you and 10, it's the law.
My lord,
It's just the law
I
on either
request.
party.
I request, because there is no, there is a, I know there is a certificate and I can respond, but I request for a short break to enable me just confirm where my certificate is, show it to my colleague. Hopefully he will concede.
Sorry?
My lord, I was just requesting, because the nature of the objection and the ruling that may be made may be substantial, so that I may even be able to get case law, because I'd only hoped and thought that because the nature of ambush that my colleagues are playing as such.
It is not an ambush, Mr. Ochoa. If you can remember, let me remind you. You know they wanted me to make a ruling.
Yes.
Before, I said no, that is not how I understand the law. I understand the law to be saying, wait until somebody wants to use. I cannot shut it out until, so it's not an ambush.
My lord, yeah, in the nature of the way we intended to proceed, where I was just to adapt the evidence of my witness, I will want to supply you with case law that disapproves the application. So kindly give me a few minutes so that I can put my house in order, respond appropriately, so that there is no injustice occasioned to my client by a hasty response. Considering my lord will notice that I've just been from leading the witness, I've been hit by 106 capital B, I have my certificate, but I'd wish my lord to just refer, because I'd wish you to make a substantive ruling on needs, guided by what your colleagues and possibly yourself have determined previously. So that if I just respond casually and the court goes and makes a ruling, because you know we are beating time, I may cause injustice to my client. So that I make an informed.
So how many minutes are you requesting?
Give me 10 minutes, my lord. So that
10, you were 10.
yes.
And you remember your time is running, even though you are done, eh? So let each party know that.
That's fine, my lord.
Yes. Go.